try to simulate what a class would look like at SJC. Now, those that are online, please mute your microphones unless you're going to speak. I can hear you just fine, so if you want to speak, you can unmute and you can yell at me. If you're not on camera, generally speaking, well, no, not generally speaking, the rule is at SJCL, if you're coming online, you have to be on camera. Those that are here today on Zoom, you don't have to be on camera. I know you might be at work doing those types of things, so you don't need to be on camera, but make sure you're muted. If you're on camera and you want to talk with me, you want to say something, I'm looking at you here. You can see me here, but you're on a TV screen here to my left. So if you see me looking at you to the left, that's why I'm looking to the left, right? You can raise your hand if you want to speak if you want to. Please put your mics.
Finders. So they come in. Oh. I can't hear you.
Now, can you hear me?
Yes.
Okay.
All right, so we're good. You didn't hear anything I just said. You hear me perfectly right now, right?
Yes.
Okay, excellent. Now, this is what it's gonna sound like in class. I'm gonna redo what I just said. I'm gonna try to simulate what it's like to be in a class at SJCL. Okay, those that are online, please mute yourselves now. Okay, if you want to speak with me, you can unmute and yell at me. You can raise your hand. There's a rule at SJCL that if you're online, you need to be on camera. I understand that many of you are at work, you don't need to be on camera. But if you want to talk with me, if you want to interact, please be on camera so I can see you. I don't monitor the chat at all, so if you want to speak to me, you can turn your mics on and speak with me. It's a lot easier if I can see you when you're speaking to me. Now, the camera's right here, I'm pointing at it, but you're here to my left, those are on Zoom. So I'm looking at you and I'm looking this way, I'm actually looking at you. It's a little strange at first, but you get used to it, right? Okay. Now, a law school class is a bit different from undergrad. Undergraduate, if you remember, you would have a PowerPoint up here and you follow the PowerPoint. Professor would read the PowerPoint to you. That's not what we do here. What I have you do is what I've done is I have you read cases and we walk through those cases together. I usually will call on someone to do what's called briefing a case in contracts. That involves you are telling me first who the parties are, what the facts are, what the beef of the contract claim is, what the issue of law is, what the rule that applied, and how it comes out, how the court decides the outcome of the case. And we talk about if you like that outcome, if we agree with the court, if the court applied the rule correctly. So that's what we're going to do today, right? So I gave you a couple of cases, Hawkins v. McGee and Allison Sullivan versus James O'Connor. So we're going to talk about these two cases, and in a normal class, I would just call on you. But I'm going to be nice today. I'm going to ask if I can get some volunteers. I mean, I know it's scary to be called on, but at SJCL, it feels like, after a couple of weeks, we're all kind of a San Joaquin College of Law family here, so it gets a lot easier to be called on. So anyway, who wants to volunteer and tell me just what Hawkins and McGee, who are the parties in Hawkins and McGee? Obviously, we've got Hawkins, right? We've got Hawkins and we've got McGee. Who are these people? Anybody want to talk with me here? Hawkins v. McGee. Online? Yeah, please, go ahead.
Hawkins is the plaintiff and Edward McGee is the defendant.
Okay, so Hawkins, so McGee here. Now, plaintiff defendant, right? Can you explain who these parties are so we kind of have an idea of what the issue is? Who is Hawkins?
Hawkins was a patient.
Patient. Okay, so we have patient here. Okay, we've got McGee.
Who is a physician.
Physician, doctor. Good. Okay. Now, what do they contract for?
Well, the alleged contract is the doctor was supposed to perform a surgery on the patient's hand.
This arrow is gonna go here. The doctor is gonna perform a surgery. Okay, on the hand. Okay, and Hawkins in exchange is gonna do what?
Assumingly pay him.
Pay money, right? So pay money for surgery. That's what we're looking at. That's the basic deal we're looking at, right? The alleged deal, correct? Good. Okay, now, when we are dealing in contract law, okay? We think, what type of communications are we worried about, do you think? So let me give you an example. Let's say I come to you and I say, look, I offer you my 1967 Mustang, and I offer you two for $500, right? That's what I say to him. Everyone can see this? He's like, that's great, I accept. I say, wait a minute, but I was really thinking $50,000, okay? Which one in contract law do you think is more important? The kind of the objective, so what a reasonable person would think of how a reasonable person would have viewed my communication, or I'm actually thinking in my head? What do you think?
Probably the first part.
First one, why?
You gave information specifics. Specific information about a car and a price. And a deal.
Yeah, so if we don't do the reasonable person standard, if we don't go by what the reasonable person would expect from that communication, and we're always looking into someone's mind, what problem do we have with that?
Can't read their mind.
Can't read their mind. Who knows when we're gonna ever have a deal, right? Okay, now, in this situation, both of these cases deal with in the medical field, right? Okay, now, just so you know, in the medical field, there's a couple of, the second case that I gave you, there's a couple of claims there, and this one could sound on this claim as well. There's one in tort, which is, this is a civil wrong, right? So have you ever heard of negligence? So a civil wrong and negligence. So, for example, in the physician's case, we have a standard of care. Like this is how the doctor has to perform a surgery, right? Standard of care, we expect the doctor to perform at this level. If a doctor's performance falls under that level, we have an action in tort, okay? Now you see the second case we have today, they sued both in contract and in tort. Jury found that there was no negligence, so we have tort kicked out, right? So we're not looking at this idea of negligence, everybody. We're not saying the doctor fell below a standard of care. What we're looking at in contract law is enforcement of a promise, right? So my question to you is, in Hawkins v. McGee, did doctor make a promise? What do you think? Let's take a look at the communication. So we know you make a promise through communications. So what are some of the communications we've got here? We've got patient's father saying, how long will the boy be in hospital, right?
3 or 4 days.
We got the doctor responding 3 or 4 days, not over 4. Okay, kind of an estimation, right? Then the boy can go home and it will be just a few days when he will be able to go back to work with a good hand.
Yeah.
Okay, now, if you're a reasonable person looking in that communication, would you say that's an estimation, or would you say that's a direct promise? Is the doctor making a promise there, do you think? If you were thinking about that, you're like, no, doctor's making a promise that he'll be ready to go in 3 days, home, ready to work. Are you thinking maybe this is an estimation, or maybe this is a?
You said not over 4, that's a definitive timeline, I think.
So we have right here, we're like, not over 4. I promise to have them done within 4 days, right? Okay, anyone else want to argue the other way? That's what we do in contract law. We're like, this reasonable person would think, hey, he's making a promise to be done within 4 days. Another reasonable person, do you think there's an argument that maybe this is simply, hey, this is what I expect, no promises, but this is what I expect? Could you make an argument that he's saying, hey, this is what I expect, no promise, but this is what I expect? You can make that argument, right? That's what we do in law. You make these arguments, okay. Now, what's the next communication we've got? No, though.
Go back to work with a good hand, I would say, is a promise.
Go back to with the good hand, it's questionable right there, right? Go back to work with a good hand, when, just a few days, maybe that's a promise or not. But we have a subsequent communication that I think is more objectively a promise. And what is that communication?
Oh, I will guarantee.
Okay.
Yeah.
This right here, everybody, I will guarantee to make the hand 100% perfect hand, or 100% good hand. Okay, what's the problem with the guy's hand? It happened when he was a kid, now he's older. What happened to his hand?
There's scar tissue from an electrical burn on the.
Electrical burn, scar tissue, right? Okay. So what does the surgery entail?
uh,
Skin grafting, right? Skin grafting from the chest, I think, to the hand, guaranteed to make perfect hand. Now, this objective manifestation for me looks like, hey, I promise this, right? This looks like a contractual promise to me. He's promising a 100% good hand, right? So you see, we're not in negligence here. There's no standard of care we're looking at. We're simply this doctor, everybody, whatever the standard of care is over here, whatever the tort standard of care negligence, doesn't matter. This doctor made a promise, 100% good hand. So we're gonna enforce that if it's a contract for 100% good hand. Okay. Did the doctor deliver 100% good hand? Anyway, tell us. Did the doctor deliver 100% good hand?
No, it did not. No,
What was wrong with the hand? Is it 100% good hand? It's not, right? What's wrong with the hand? Just for purposes, this case is called the case of the hairy hand, right? Because the hand started growing hair, okay? From the skin graft. So is a hairy hand 100% good hand? No. No, it's not, right? It's not 100% good hand, perfect hand. Does anyone have hair on their palms? I mean,
No,
it seems like that might be an issue, right? So did not deliver what he promised. So when you don't deliver what you promised, what's that called in contract law?
Reach.
Breach. Got a breach of contract. Breach, okay. Got a breach of contract, okay. Now, when we're looking at breach of contract, like, hey, this doctor did not perform what the doctor said he would perform. He is in breach, okay. So we have to do something to remedy the breach. So tell me what we could do to make Hawkins whole after this breach.
Do another surgery?
Okay, we could say, hey, we're gonna force the doctor to do another surgery. Would you wanna do that? Would you wanna force the doctor? This is what's called maybe specific performance. Say, hey, doctor, do another surgery. Would you wanna force the doctor to do another surgery here?
not up to the.
Not
The doctor's happy.
If
The doctor
anybody
be happy,
willing to do it.
and Hawkins be happy. I think the patient would be happy with the doctor doing another surgery.
Say another doctor do it and he pays for it.
Okay, good. So, good. So we'd have another doctor do it, right? We wouldn't force another doctor to do it, but we would give Hawkins enough what? Enough money to pay for another surgery, potentially, right? That's one thing that we could do, okay? To pay money. So we're looking at what's called substitutionary. You substitute the perfect performance with money damages, right? That's what we're looking at, money damages. Now, the first, what the court talks about, what is the valuation we're looking at in terms of money? And the court talks about. Just a clue. One of the theories of remedies and contracts is called expectation. Expectation. Now, not even reading that, what do you think I'm getting at with when I talk about an expectation or expectancy, what it's called as well? Expectation measurement of damages. What do you think I'm getting at here? Anybody?
Expectation of damages?
Yeah, we think the expectation measurement, this theories, we've got theories of damages here. One is called expectation or expectancy from perspective of the patient. Contract, what do you think?
Pain, suffering.
Trying to figure out how to word it.
Generally speaking, what do you think? Now, this is kind of easy. Like, okay, let's say in the commercial aspect, right? I order grade A oranges, right? Okay. And I expect grade A oranges. You deliver grade B oranges, right?
Make you whole, I guess.
To make me whole as if what? So the expectation is to give enough money to the non-breaching party to put them in the position they would have been had performance happened. Okay. So what we're looking at is we're putting the aggrieved party in position if contract were fulfilled, right? Were performed. So we call on contract, we call it performance. So the performance on the patient side is to give money, the performance on the east side is to the surgery hand. So this expectation measurement, we're putting Hawkins in the position that he would be in if the contract would have been performed. One of the ways we can do that, right? Say, okay, we're gonna give enough money for a doctor, another doctor to do it. If it's impossible now for another doctor to, how else could you think about expectation damages? Think about the difference between what was expected and what was delivered, right? So you would say, potentially Hawkins would say, look, I want the difference of value between what you promised, which is what?
Perfect hand.
A perfect hand, and what you gave me, which is what?
A hairy hand.
A hairy hand. What is the money damages there, right? So if you're thinking about this, how do we figure that out, right? Potentially, a hairy hand doesn't allow him to work anymore when he's working. As an electrician, maybe it's slippery now. I don't know, right? Potentially he has to go have laser surgery, and this is way back in the day, right? So I mean, so maybe that would be included, right? But you're looking at,
Buy more razors.
buy more raise, you're looking at putting that person in the position they expected to be in. Giving them money to put them in a position they expected to be in. So the difference between grade A oranges or grade B oranges, difference between a hairy hand and a non-hairy hand, right? It's making sense? Good. Okay, what time we have? 20, okay. So the second case, which is from the 1970s, happened in the 60s, refers to this case, specifically to this expectation measurement. And then we're gonna add some different theories of recovery here. Okay, so this is what we do. We pull out our rule from one case, and we read another case, we pull out that rule, we add these rules together, and we come up with rules of contract law, right? That we've kind of walked through together and derived together. And at the end of the semester, I give you a fact pattern, right? That might be similar to some of the cases that you've seen. And you're gonna say, okay, I can see this person made this representation, potentially it's a contract, and you would apply you get the rule that we learned from class, and you apply the rule to the new set of facts that I give you, right? Okay, so the new set of facts we're looking at now is what? Same setup, correct? So the rule from this case, right? Hawkins expectation damages. We're gonna give the person the difference between what they expected and what they received. It's called expectation damages, okay? Between a hairy hand and a good hand. Now in Sullivan versus O'Connor. Okay, so same way. Who are the parties?
Sullivan and James O'Connor.
Sullivan, okay, then give me Sullivan, O'Connor. So tell me a little about Sullivan.
Entertainer of some sort.
Entertainer, right? So we got an entertainer, actress, right? An actor, okay? We got O'Connor, who is who?
Surgeon.
A surgeon again, right? So we've got this surgeon again. ER. Okay. So we got surgeon. Okay. Actor and actress, okay. Now, what is Sullivan looking for O'Connor to do?
Fix her nose.
Fix her nose, good. What's wrong with her nose? How would her nose describe, Star?
It said, oh my God, I had, basically, it was just longer than the other features of her face. So
Oh.
she just wanted it shorter.
Right, so it says it had been straight, but long and prominent, right? So, okay, so straight, long and prominent, we wanted to have O'Connor perform surgery. How many surgeries were included?
2.
2, but then there was an extra surgery done, right? So again, we have this arrow. Running out of these, actually out of ink. Could you run over to this 210 and grab me one of these?
Yeah.
So Connor's gonna do 2 surgeries. Okay. Exchange. Sullivan's gonna pay money. Sullivan in fact did pay money, correct? So $600 something maybe, can't remember. All right. Now, but did Sullivan get what she bargained for? Maybe Star can help me, keep helping me, Star. Did she get what she bargained for?
No, she got a deformed nose.
She got a deformed nose. It was worsened. Her nose now had a concave line to about the midpoint, at which it became bulbous. Frontally, the nose from bridge to midpoint was flattened and broadened, and the 2 sides of the tip had lost symmetry. Okay, so the nose got a lot worse, right? Okay, now, a little background on this case. Ellison Sullivan asked for a nose akin to that nose of Hedy Lamarr. Does anyone know who Hedy Lamarr is? 1950s or 60s, an actress from Austria, came to Hollywood. Great nose, just great nose, right? So wanted the Hedy Lamarr nose. She did not get the Hedy Lamarr nose, right? Okay. In fact, James O'Connor, his doctor, he moved to California to get a law degree after this. So he could specifically defend against the 44 cases or something that were against him. So anyway, he'd been doing this often, I think, right? Not doing a good job. Okay, so Sullivan did not get the Hedy Lamarr nose after 2 surgeries. Okay, now Sullivan files an action for 2 claims. What are those claims?
Those pain and suffering.
So before we get there, one was in negligence, right?
Okay.
Negligence, so negligence and in contract, how did the jury find that the negligence became? The tort claim, the negligence claim, standard of care. Surprise, they said no. They said there's no liability with regard to negligence, okay? But they did find breach of contract and they awarded $13,500. Okay, so they did find breach of contract. Now, a couple of questions here. There's always this there's always this theory of negligence in law pertaining to medical procedures, right? So you're always protected by this idea of negligence that if a doctor drops below the standard of care, depending on what the procedure is, they can be held liable. Okay. Separate to that is this idea of contracts, that a doctor can make a promise, okay, and that they would be held liable for that promise. Okay, so this court talks about whether or not we should enforce, number one, should we enforce contracts of this sort? Should we enforce contracts with doctors making promises? Why or why not?
It said you shouldn't enforce it because, what was it? Because then they'll be they'll be scared to perform their practice and perform surgeries.
Yeah, so why would they be, so if we held doctors responsible for things that they say, right, in contract law, they would perform what's called defensive medicine. They wouldn't take, sometimes they need to take risks to get the best outcome. And this would dissuade doctors from taking risks so imagine you were the doctor says, hey, look, I think this is gonna go well. You know, I think we can do this. I think your kidney surgery is gonna turn out well, right? Okay. Now, if that is a contractual promise, you know, you're not gonna have any doctors ever giving opinions like that, right? Because they're gonna be held accountable for that. And sometimes patients need a doctor to have kind of optimism, correct? So maybe we shouldn't enforce contractual promises from doctors in these terms, okay? On the other hand, why should we enforce contractual promises from surgeons?
You're paying them to do it when this doctor tells you everything you want to hear, so he gets your business, when this doctor was more optimistic about, well, it may work, you know, we can try this, but this guy says, hey, guarantee this is gonna work. It's gonna so,
Yeah, if you go to a doctor, who tells you it's gonna be successful no matter what, it's right? The mercy, what they call charlatans, who will overpromise and underdeliver if they know that we're not gonna enforce contractual promises. So the court says what? We will they decided, yeah, like, we can enforce these types of promises, provided that what? There's clear evidence, right, that the promise was made. It's not simply an opinion, that there's this objective manifestation that the doctor actually is promising to perform at a certain level, right? So assuming that happened here, the doctor said, I will give you a Hedy Lamarr nose. And what we know about this doctor and overpromising, that he probably guaranteed a Hedy Lamarr nose, right? Okay. So what was delivered was not a Hedy Lamarr nose, which is called what?
Breach.
Breach of contract. Okay, so we've got another breach here. Okay, breach of contract. Now, this here. Actually, so we got this down. Now, how are we going to make the patient whole here? Okay. Now, there are some theories of recovery that this court adds to what we just talked about, right? One of those, so I'm gonna call expectation 3, is called restitution. Okay. Restitution is judged by what the defendant or the doctor receives, right? So we're gonna turn anything plaintiff confers to defendant. Okay? Of a restitution, return anything plaintiff confers to defendant. You're looking at the defendant and you ask yourself, what did the defendant receive? Do on the from this contract, and we're going to return that to the plaintiff, okay? There's also another measurement. It's not restitution or expectation. If you looked at that, anybody, do you know what that's called? In case
Punitive.
there are punitive damages not generally available in contract law.
Reliance.
Reliance, Caroline, thank you. Reliance. Okay, how do we measure reliance damages? I'm gonna turn the AC on here. They're hot in here. You're okay?
Yeah, I think.
Okay, reliance. How do we measure reliance damages?
Measure, oh,
Go ahead, Caroline.
measure by an amount of money to put plaintiff back in the position just before the parties entered the agreement.
Perfect.
Yeah.
Plaintiff in position as if they never met, right?
Right.
In status quo, okay. Status quo, in other words, as if contract never happened. Never happens. Okay, everyone follow that? As if contract never happened. So as if they never crossed paths. So this is from the perspective of a plaintiff. You think to yourself, okay, plaintiff in reliance on this contract now has suffered things, right? Has paid money, has suffered things, right? We're gonna put her in the position as if the two never crossed paths, okay? Now, again, these are theories of recovery. We can mix and match these, or sometimes they overlap, a lot of times overlap. But if you were Sullivan, okay, what types of damages would you be looking for? Just, so you said pain and suffering, that what you said? So pain and suffering based on what?
Additional surgeries.
So pain and suffering, everybody. So we've got, let's separate this out into surgery number 1 and 2. Right, surgery 3. Okay, what else would you be looking for?
Mental distress from the botched job.
Mental distress from botched job, good. What else?
Loss of future earnings.
Loss of earnings. Okay, so maybe past, right, and future. So maybe concurrent with the surgery in future, okay? What else? Be creative here. Okay. Earnings past, future,
Legal fees.
legal fees. Legal fees, okay, what else? Be creative. Someone with the Hedy Lamarr knows, you think they're gonna get more jobs than. So missed out opportunities in the future, potentially. So loss of earnings, that could go here as well, loss of future jobs. That make sense? Okay, what else?
Negative effects on her social life.
Okay, negative effect on social life, on the love life, maybe? Social life. Like it. What do you think?
Like,
Go ahead, Katrina. I didn't hear that, I'm sorry, could you repeat that? Okay, go ahead.
maybe medical bills that come with the deformation, maybe it causes other.
Future medical bills, okay? Future medical bills. So medical bills. Okay. What about like the case of the hairy hand, the difference, you know, Hedy Lamarr nose and a bulbous nose? Right, something like that, difference in noses. You'd have to stretch your imagination to figure out what that would mean. Does that mean, you know, better jobs in the future, difference in value of noses? Maybe another surgery? The fourth surgery? Let's see this goes. Fourth. Okay, now. Legal fees, medical bills. So these medical bills, let's see, there's a doctor's fee, you saw that, right? There was also a hospital fee, you saw that? Okay. Doctor's fee, hospital fee. You can also have future. Okay, now. So look at this, let's apply these theories that we've got to these. Let's figure out which of these categories fit with these types of damages. Okay, now restitution, return anything plaintiff confers to defendant. Okay, so what did the plaintiff specifically confer on defendant?
Doctor's fee.
Doctor's fee, right? So the doctor's fee. So we know that this is gonna be restitution. Okay, so that's restitution. What about the hospital fee? Did the plaintiff give that to the doctor? So we got a doctor's fee, right? So if you know, I know this because I work in the medical field, you know, there's a doctor's fee the doctor gets and a hospital fee the hospital gets for them to use the hospital, right? So the doctor doesn't receive the hospital fee. So if the doctor doesn't receive the hospital fee, would she be able to collect that from the doctor in restitution? Remember, we're basing this on what plaintiff specifically gives to defendant. Defendant has to return that. So if defendant never got the hospital fee, defendant does not have to return the hospital fee, right? That wouldn't be restitution. Hospital fee wouldn't, this is restitution, doctor's fee, hospital fee is not restitution. What about legal fees? Is that restitution? Did plaintiff give that to the defendant? Loss of earnings, you see what I'm saying? So none of these fit with restitution. None of these things were not giving anything back to the plaintiff that was conferred to the defendant, right? Okay. So the only thing here is that doctor's fee and restitution. All right. What about reliance? So now from the plaintiff's perspective, what is plaintiff out with regard to this contract? And what is it, what's the amount of money, or how can we put her back in the position she would have been as if the contract never happened? Okay, so doctor's fee?
Mhm.
And reliant on that contract, right? She paid a doctor's fee to get her back to status quo. We have to give her that doctor's fee, right? So this is reliance as well. That's reliance. What about hospital fee?
Yes.
Yeah, to put her back in the status quo, we gotta give her the hospital fee. That's reliance. What about legal fees? Maybe she had to pay legal fees to, right, bring this case, so put her back in the status quo, that's good, we could give legal fees. That's reliance. What about loss of earnings?
No, would not fall under restitution.
So restitution is if she's given anything to the defendant has to give it back. Did she give loss of earnings to the defendant? No, right? She didn't give loss, so it can't be restitution. Because restitution is just giving back what she gave to the defendant, right? So this has got to be reliance. The loss of her past loss of earnings, right? If she's had to stop work to get the surgeries, everybody. If she had to stop to get work to get the surgeries, then what? And we have to give it back to her. We have to in reliance damages, right? Not give it back. It's the wrong way of saying that. So these are reliance. What about future loss of earnings?
Reliance.
Reliance too, so this can consider reliance, good. Can be considered reliance, okay. What about pain and suffering? Surgery 1 and 2. Get her back as if they'd never met.
Reliance.
Reliance, yes. Remember, putting her back in the status quo, so reliance. What about surgery number 3? Put her back in the status quo. Reliance, good. Mental distress, put her back in status quo.
Reliance.
Reliance. Hit to her social life.
Reliance.
Okay. What about difference between the value of noses, what she expected and what she got?
Reliance, I would say.
So so here we go. This is good. So value between current nose and starting nose. Whatever value that is, that would be reliance, right? Difference of value between current nose and expected nose. That wouldn't be reliance, that would be expectation, right? But good. Okay. 4th surgery to correct. Potentially reliance for correcting it back to status quo rather than what she expected, okay? I want to differentiate reliance, okay, with expectation, okay? Now, most of this stuff, to put her in a position she would have been, okay, as if if the doctor fulfilled the obligation. If the doctor, can we get under expectation, can we give the doctor's fee and hospital fee back to her under expectation? Wouldn't she have had to pay that? She would have to pay that if the doctor would have fulfilled the obligation, so no, we can't give that under expectation, right? Because she would have had to pay that for the doctor to fulfill the obligation, correct? Okay, what about loss of earnings? Past loss of earnings. So say she had to take work off to get the surgery. Is she gonna get that money in expectation? Had the doctor performed, she would have had to take work off, right? And would have had to lose that money for the doctor to perform, got it? So bad expectation. What about future earnings, future jobs?
That could be. No.
That is expectation, right? That's more expectation than even reliance. Expectation. So this idea, and this could be substantial money, if you could prove, hey, I have this, and this contract to be in this movie, right? And they wanted a Hedy Lamarr nose. I don't have a Hedy Lamarr nose, I was gonna make $1 million, right? That's not reliance, that's expectation. That's where she expected to be. So it could be substantial, you see? What about pain and suffering for surgery 1 and 2? Can that be collected under expectation? Again, if the doctor would have performed correctly, she would have a Hedy Lamarr nose, but she would have had to suffer through 1 and 2, correct?
1, maybe not.
I think it was contract, maybe one. I think it was contracted for 2 different surgeries, but maybe just 1. But whatever it would have taken for her to get the Hedy Lamarr nose, had the doctor performed, everyone follow this, she would have had to suffer this. Anything outside the scope, right? Then she could collect maybe for the second surgery and the third surgery for sure, if this wasn't contemplated by the parties, right? She could do that for expectation. But you're thinking in the hypothetical world, had the doctor performed, delivered a Hedy Lamarr nose, she would have had to pay that money, right? She would have had to suffer the pain and suffering from these surgeries, right? So wouldn't be able to collect there, but potentially collect a lot more in future earnings, correct? What about mental distress from the surgeries? Again, or not from the surgery, but just general mental distress.
Same, she probably would have experienced some mental distress by going through the surgeries anyway.
There would have been some mental distress, right? What about future mental distress? To put her in the position that she would have had the doctor performed, she wouldn't be having mental distress about the nose later, right? So that future mental distress is now covered as well under expectation. Making sense? Future mental distress covered. What about the social life? What about loss of the social life or loss of consortium or something?
No,
Why not?
because with that, with her new nose, she's already in distress and she's already anxious about it and feeling as if, you know, she does not looking as what she expected to be able to have that relation to the heady nose.
She expected to be with assuming we can prove this, Alex, we can prove that she expected to have a Hedy Lamarr nose and a new significant other, right? And now she doesn't have a Hedy Lamarr nose and she doesn't have a significant other and she's suffering on her social life, right? She expected to be Hedy Lamarr nose, great social life, and assuming we put money on this, she's not there. So expectation and where she is now, we got to get to her there, right? So this could be collected in expectation as well, right? Okay. What about the value of noses now? Current nose to expected nose. Again, that's your clue, that expected nose, right? This would be evaluation, would be expectation. Expectation. Okay. Now, as you can see, a lot of these, like in Reliance, for example, a lot of times Reliance will cover restitution. But if you're an attorney and you're looking at someone's contractual breach, every contractual breach is different. You can kind of decide, you know, where you're going to get the most money for your client by using a range of these, right? Okay. So you can see we started with Hawkins v. McGee, right? And what did we draw from Hawkins v. McGee? This expectation rule, correct? Expectation rule, what else? How do we judge communications in contract law? Using the objective criteria, right? So what is objectively manifested, we learned that. We also learned what the expectation measurement is. Difference between what was expected and what was delivered, right? Okay, we've got that rule down. Then we move to the second case and we've added values, we've added theories of recovery, right? So you would, in your what's called an outline, you would have these rules written down from what we collect during class. You would have all of them. You create this outline that you're going to use on the final exam. You're going to memorize and use on the final exam, right? So we learned about restitution, we learned about reliance. What else did we learn here in this case? Are we going to enforce contracts from physicians? Yes, provided there's clear evidence that there was a promise, right, that can be enforced. Good, okay, now, that is basically what a contracts class looks like. Or at least the first 45 minutes of a contracts class, and we would continue doing that, right? Every day until the final exam. Is there any questions about anything you just saw? Not about the content. When you start law school, we start from a different place. We start with this an offer. What's an offer for a contract? What's an acceptance? What types of contracts are enforceable in court? Gives you a good idea of procedure. So is there any questions about law school in general, procedure, or any other questions you've got?
Professor Atkinson, can I ask you, so in terms of this content on the board, are you saying that the rules are remedy, restitution, and expectation?
You would, yeah, you would use those rules for what's called remedies, yes, you would.
Okay,
And you would include those, and you would apply these rules to different sets of fact patterns. So we would continue with facts, continue with cases, and we would add to this. And you would use these same rules on another fact pattern or on hypotheticals that I give you, yeah, but these would be the rules that you would be including in your outline. Good question.
I have a question, not regarding the content though, just speaking of expectation. For an incoming student on the first day, what is your expectation for us as far as like the know-how? Like what should we come prepared, already prepared for the first day?
We're gonna have an orientation week. During that orientation week, they're gonna teach you some good study habits. You're gonna have your research and writing class 3 times. So they start off saying, this is what you're going to expect in your substantive classes, right? For contracts, I'm actually your first substantive class that you will have. I expect you're having read the cases that I assigned from beforehand, right? And be able to discuss them as we have. So you'll be able to say, here are the parties, here are the facts, here is the rule that I think the court applied, and this is how the court applied that rule. That's what I'm looking for. That's what most of your classes are looking for, right? So again, you're gonna have a nice orientation week. Well, that's gonna be described even further for you.
Thank you.
Mhm.
This is an irrelevant question, but whatever finally happened to Dr. O'Connor? He got his law degree and then
He did get a law degree, but I don't know what happened actually after that. And so you should Google that, see if you can find that.
Oh God.
But I know he did get his law degree in California. Anything else?
yes, in such cases as those, would we also IRAC contract like offer, acceptance?
You would, so in these cases, so when you come to contracts course, we'll start with offer, for example. We're gonna have cases specifically dealing with offer. So offer and acceptance really aren't issues in this case. Right? The issues here are remedies and some other things. So specifically, there's no offer or acceptance in these cases, but you will see cases where there's offer and acceptance issues, but you only discuss the issues if they come up in the case. And you'll
Okay,
more about this as we go on.
thank you.
Okay. All right, I think Diane's gonna hang out, right?
Yeah.
Answer questions.
Fantastic. Professor Atkinson, thank you so much for simulating this mock law class experience for everybody. And before we say goodbye, Professor Atkinson, can you share with these students anything that you were passionate about as a person in law school yourself?
I love our students. Our students have, what I love about them is they work together. One great thing about SJCL is there's no curve. So you're not battling with other students for A's or B's or C's. You know, everyone can score well if they do well. So it's very, very collaborative. I'm impressed with the diversity and the background and otherwise of our students in terms of we've got people who do not do well on standardized tests because they didn't practice standardized tests, right? We've got parents, we've got full-time workers, we've got older people such as myself, we've got younger people. They all find a way to make the program happen. So I've seen, single mothers of 4 children working full-time come through this program, do well, and pass the bar exam. There's no way I could do that. So SJCL students for me are inspirational. They're an inspiration to me. That's why I love my job. So
Awesome. Thank you. Thank you so much, Professor Atkinson. We really appreciate you. And yes, I will be staying on the call. So please, if you have any questions and you want to stay, please do.